Hello friends. Welcome to Grofin's online learning module. In this session, we will understand cyber laws in elements of IT Act. In this module, we will look at provisions of e-governance, and what is cybercrime, its meaning, and against whom it can be committed, the scope of cyber law. This topic is part of CS Foundation course, Paper 1 Business Environment and Law. For detailed learning, you can enroll on our website www.grofin.co.in. Cyber law encompasses the legal, statutory, and constitutional provisions that affect computer and computer networks. It concerns individuals, corporate bodies, and institutions which are instrumental for the entry into cyberspace, provide access to cyberspace, create hardware and software which enable people to access cyberspace and use their own computers to go online and enter cyberspace. It is a generic term which refers to all the legal and regulatory aspect of Internet and World Wide Web. Anything concerned with or related to or emanating from any legal aspects or issues concerning any activity of citizens and others, in cyberspace comes within the ambit of cyber laws. Now let us understand Information Technology Act. India is the 12th nation in enactment of cyber law with the passage of Information Technology Act, 2000. The Act provides legal recognition for transactions carried out by means of electronic data interchange and other means of electronic communication, commonly referred to as electronic commerce, which involves the use of alternatives paper-based method of communication and storage of information, to facilitate electronic filling of documents with the government agencies. The Act amended the Indian Penal Code 1860, the Indian Evidence Act 1872, the Bankers' Books Evidence Act 1891, and the Reserve Bank of India Act 1934. Now, the following are the objectives of the Act. To grant legal recognition for transactions carried out by means of electronic data interchange and other means of electronic communication commonly referred as e-commerce in place of paper-based method of communication. To give legal recognition to digital signature for authentication of any information or matter which requires authentication under any law. To facilitate electronic filling of documents with government departments. To facilitate electronic storage of data. To facilitate and give legal sanction to electronic fund transfer between banks and financial institutions. To give legal recognition for keeping books of accounts by bankers in electronic form under the Evidence Act 1891 and the Reserve Bank of India Act 1934. Key features of the Act. Electronic contracts have been made legally valid if made through secure electronic communications. Legal recognition has been granted to digital signatures. Security procedures for electronic records and digital signature have been laid down. A procedure for appointment of adjudicating officers for holding inquiries under the Act has been laid down. A provision has been made for the establishment of Cyber Regulatory Appellant Tribunal under the Act. An appeal against the order of the controller or adjudicating officer can be made to Cyber Appellant Tribunal and not to any civil court. Appeals against order of the Cyber Appellant Tribunal are to be made in the High Court. Digital signatures are to be effected by use of asymmetric crypto system and hash function. A provision has been made for appointment of controller of certifying authorities, that is CCA, to license and regulate the working of certifying authorities. The controller is to act as repository, a storehouse. That is, who will maintain an authentic and complete information of all digital signature certificates. The Act is to apply to offences or contraventions committed outside India. Senior police officers and other officers have been given power to enter any public place and search and arrest without warrant. Provisions have been made for the constitution of a Cyber Regulations Advisory Committee to advise the central government and the controller. Exceptions to the IT Act. As provided in Section 1.4, the provisions of the Information Technology Act, 2000 shall not apply to the following documents. Execution of negotiable instrument under Negotiable Instruments Act, 1881 except checks. Execution of a power of attorney under the Powers of Attorney Act, 1882. Creation of trust under Indian Trust Act, 1882. Execution of a will under the Indian Succession Act, 1925, including any other testamentary disposition by whatever name called. Entering into a contract for the sale of conveyance of immovable property or any interest in such property. Any such class of documents or transactions as may be notified by the central government in the Gazette. The Information Technology Act provides for the following provisions in context of electronic governance. 1. Legal recognition of electronic records. Section 4, where any law provides that information or any other matter shall be in writing or in the typewritten or printed form, then, notwithstanding anything contained in such law, such requirement shall be deemed to have been satisfied if such information or matter is rendered or made available in an electronic form, and accessible so as to be used for a subsequent reference. 2. Legal recognition of digital signatures. Section 5, where any law provides that information or any other matter shall be authenticated by affixing the signature or any document shall be signed or bear the signature of any person, hence, notwithstanding anything contained in such law, such requirement shall be deemed to have been satisfied, if such information or matter is authenticated by means of digital signature affixed in such manner as may be prescribed by the central government. 3. Use of electronic records and digital signatures in government and its agencies. Section 6(1), where any law provides for the filing of any form, application, or any other document with any office, authority, body or agency owned or controlled by the appropriate government in a particular manner. The issue or grant of any license, permit, sanction or approval by whatever name called in a particular manner. The receipt or payment of money in a particular manner, then, notwithstanding anything contained in any other law for the time being in force, such requirement shall be deemed to have been satisfied if such filing, issue, grant, receipt, or payment, as the case may be, is effected by means of such electronic form as may be prescribed by the appropriate government. 4. Retention of electronic records. Section 7(1), where any law provides that documents, records, or information shall be retained for any specific period, then, that requirement shall be deemed to have been satisfied if such documents, records, or information are retained in the electronic form, if the information contained therein remains accessible so as to be usable for a subsequent reference. The electronic record is retained in the format in which it was originally generated, sent, or received, or in a format which can be demonstrated to represent accurately the information originally generated, sent or received. The details which will facilitate the identification of the origin, destination, date, and time of dispatch or receipt of such electronic record are available in the electronic record, provided that this clause does not apply to any information which is automatically generated solely for the purpose of enabling an electronic record to be dispatched or received. 5. Publication of rules, regulations, etc., in Electronic Gazette. Section 8, where any law provides that any rule, regulation, order, bylaws, notification or any other matter shall be published in the official Gazette, then, such requirement shall be deemed to have been satisfied if such rule, regulation, order, bylaw, notification or any other matter is published in the official Gazette or Electronic Gazette, provided that where any rule, regulation, order, bylaw, notification or any other matter is published in the official Gazette or Electronic Gazette, the date of publication shall be deemed to be the date of Gazette which was first published in any form. 6. Section 6, 7, and 8 not to confer right to insist document should be accepted in electronic form. Section 9 nothing contained in Section 6, 7 and 8 shall confer a right upon any person to insist that any ministry or department of the central government or the state government or any authority or body established by or under any law or controlled or funded by the central or state government should accept, issue, create, retain and preserve any document in the form of electronic records or effect any monetary transaction in electronic form. 7. Power to make rules by central government in respect of digital signature. Section 10. The central government may, for the purposes of this Act, by rules, prescribe a. The type of digital signature, b. The manner and format in which the digital signature shall be affixed. C. The manner or procedure which facilitates identification of the person affixing the digital signature. D. Control processes and procedures to ensure adequate integrity, security, and confidentiality of electronic records or payments, and E. Any other matter which is necessary to give legal effect to digital signatures. Cybercrime can be classified on various bases, such as on the basis of A. Subject of crime, B. Against whom crime is committed, and C. On the basis of temporal nature of criminal activities being carried out on computers and Internet. The subject of cybercrime may be broadly classified under the following three groups. Against individuals, it may be committed against individual person or property. Following are some crimes that can be committed against an individual. 1. Harassment via email. 2. Cyberstalking. 3. Dissemination of obscene material. 4. Defamation. 5. Unauthorized control/access over computer system. 6. Indecent exposure. 7. Email spoofing. 8. Cheating and fraud. Following are the crimes which can be committed against individual property. 1. Computer vandalism. 2. Transmitting virus. 3. Net trespass. 4. Intellectual property crimes. 5. Internet time thefts. Against organization. Following are the crimes that can be committed against organizations. 1. Possession of unauthorized information. 2. Cyber terrorism against the government organization. 3. Distribution of pirated software. Against society. 1. Polluting the youth through indecent exposure. 2. Trafficking. 3. Financial crimes. 4. Sale of illegal articles. 5. Online gambling. 6. Forgery. Now let us understand the scope of cyber law. The scope and relevance of cyber law touches those areas which have a technological bent, such as e-commerce, e-taxation, copyright, trademark, etc. The scope of cyber law would keep evolving with the dynamic nature of business world. Some areas of concern for cyber law are listed below. E-commerce, online contracts, business software patenting, e-taxation, e-governance, cyber crimes, data protection. As per Section 43A of the Information Technology Act, 2000, where a body corporate, possessing, dealing or handling any sensitive personal data or information in a computer resource which it owns, controls or operates, is negligent in implementing and maintaining reasonable security practices and procedures and thereby causes wrongful loss or wrongful gain to any person, such body corporate shall be liable to pay damages by way of compensation, not exceeding 5 crore rupees, to the person so affected. Government of India Notified Information Technology Reasonable Security Practices and Procedures and Sensitive Personal Data or Information Rules, 2011 under Section 43A of the Information Technology Act, 2000. These rules are regarding sensitive personal data or information and are applicable to the body corporate or any person located within India. Confiscation under IT Act. Confiscation of computers or any accessories thereto, Section 76, provides for confiscation of any computer, computer system, floppies, compact discs, tape drives or any other accessories related thereto, in respect of which any provisions of this Act, rules, orders, or regulations made thereunder has been or is being contravened. However, where it is established to the satisfaction of the court adjudicating the confiscation that the person in whose possession, power, or control of any such computer, computer system, floppies, compact discs, tape drives or any other accessories relating thereto is found to be not responsible for the contravention of the provisions of this Act, rules, order, or regulations made thereunder, the court may, instead of making an order for confiscation of such computer, computer system, floppies, compact discs, tape drives or any other accessories related thereto, make such other order authorized by this Act against the person contravening the provisions of this Act, rules, orders, or regulations made thereunder as it may think fit.